Hello friends, today we will start discussion on a very interesting subject, evidence law. I will try to make a comprehensive lecture for the LLB students as well as those who are taking preparations for judicial service. Evidence Act 1872. I will start my discussion section wise. First, section 1 extends to the whole of India except Jammu and Kashmir and applies to all judicial proceedings in or before any court. I will request all of you to open your books and read with me. Again, I am reading. Applies to all judicial proceedings in or before any court, including court martial, other than court martial convened under the Army Act, Naval Discipline Act, or Navy Discipline Act or Air Force Act, but not to affidavits presented to any court or officer, nor to proceedings before an arbitrator. So the first question is applicability of Evidence Act. This Evidence Act is applicable in all judicial proceedings or before any court, including court martial, subject to some exceptions, but not before an arbitrator. So an arbitrator is not empowered to take evidence, and not to any affidavits filed in court, presented before a court. Any affidavit is not a piece of evidence, is not guided by the Evidence Act, and arbitrator is not authorized to take any evidence as per the provisions of Evidence Act. So it is clear now the scope of Evidence Act, where it is applicable, applicability of Indian Evidence Act in all judicial proceedings in or before any court, including court martials, subject to exceptions. Now, section 2 is repealed. Now we are coming to section 3, interpretation clause. Number 1, court. What does it mean? Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. So arbitration or arbitrator is not a court. Then who are the court? Court includes all judges and magistrates and all persons except arbitrators who are legally authorized to take evidence. Now, in some cases, we find in land cases in particular, block land and land reforms officer, district land and land reforms officer, they are empowered to pass order. They are empowered to pass order as per the provisions of law. But the question is whether they are court. No. Why? Because they are not empowered to take evidence as per the provisions of Evidence Act. So, block land and land reforms officer, district land and land reforms officer, and such other persons who are legally authorized to pass a binding order, but they are not a court. Now, the most interesting definition is fact. I am reading. Fact means and includes anything, state of things, or relation of things capable of being perceived by senses. Note each and every word used in this definition. Fact means and includes anything, state of things. State of things means the situation of the thing, the position of the thing, the character of the thing, or relation of things, relation between two things, capable of being perceived by senses, which we can perceive, which we can feel, which we can recognize by our senses, by our eyes, by smell, by touch, everything. So, fact means and includes anything, state of things, or relation of things capable of being perceived by senses. Number 2. Any mental condition of which any person is conscious. I am drunken, and my friend Mr. X is aware that I am drunken. So this is a fact. I am drunken, that is my mental condition. Why? Under the influence of liquor, my brain is not working properly. My brain is under the influence of liquor. So my mental condition is not normal. And my friend Mr. X is aware that I am utterly drunk and my state of mind is not normal. This knowledge is a fact. There are very nice illustrations in our act. I am reading one by one. A. That there are certain objects arranged in a certain order in a certain place is a fact. You kept your law books for any particular chapter, say for evidence. You have several books. Book A, book B, book C, book D. And you kept all these books in your bookshelf in a particular order. So first is book A, second is book C, third is book D, and fourth is book B. This is a fact. That there are certain objects, here objects are your books. That there are certain objects arranged in a certain order. You kept the book first, volume A, book A, then book C, then book D, and lastly book B. So this is a fact. B. That a man heard or saw something is a fact. My friend Mr. X saw that I am consuming liquor. This is a fact. My friend Mr. X heard from my driver that 1 hour before I have consumed liquor. This is a fact. That means if I could gather any knowledge either through my ears or through my eyes, I gathered some knowledge, some information, that is a fact. Number C, that a man said certain words is a fact. Whatever I am stating now before the camera, all these are facts because I am stating this. These are facts. Number D, that a man holds certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. Very difficult to understand. Let us break it. That a man holds certain opinions, has a certain intention, acts in good faith or fraudulently. So I have certain opinion. My opinion is Mr. X is not a good person. He is doing some ruins to our society. This is my opinion. Now, intention. Based on this opinion, my intention is to remove Mr. X from the chair, from the post he is holding. This is my intention. Acts in good faith. I think that as I know that Mr. X is not a good person and he is not working in the interest of the society, I have the right, I am authorized to remove Mr. X in anyhow, in any manner. That is, acts in good faith or fraudulently. I have taken some tricks. I know that though I know that Mr. X is not working for the interest of the society, which he is bound to do, and my intention is to remove Mr. X from the designation, from the chair he is holding. Now, based on that knowledge, to fulfill my intention, if I do some act, either in good faith, when good faith, when I am holding the opinion, I am confident that I have the right, I am the authorized person to remove Mr. X, or fraudulently, I have taken some tricks to remove Mr. X. That it is well within my knowledge that I am not authorized to remove Mr. X. That's why I have adopted some tricks. Uses a particular word in particular sense. I am using a particular word or phrase of words for a particular sense. I told Mr. X that I heard that your boss has issued a termination letter of yours. Why I said so? With the intention that Mr. X may run to his boss, have some altercation, maybe some chaos, and boss is compelled to remove him. So a particular word with a particular sense, or is or was at a specified time conscious of a particular sensation. Is or was at a specified time conscious of a particular sensation. Let me explain it. It's very difficult to understand. It took me several years to understand all these. I know that Mr. X's mother is not well and she is in hospital. He is a aged lady. He is an aged lady and not doing well, not responding well to our treatments. At this point of time, I came to the cabin of Mr. X and told him, your mother's condition is not at all good. I know that when Mr. X's mother is in hospital, this particular word or words that your mother is not working well, he is not in a good condition at all. These particular words or word will create some panic in Mr. X, and Mr. X may run to hospitals to see his mother. Why? Extra panic will be created. Why? Because her mother is in hospital and it is well within his knowledge, Mr. X's knowledge, that she is not doing well. Further, when he is getting this similar kind of information suddenly from me that Mr. X, your mother is not at all well, he may imagine something, that something has happened to his mother. So this particular word will create some panic in Mr. X. And I created this panic intentionally when Mr. X was assigned a particular very important assignment and he has to submit the assignment within an hour. This is my fraudulent intention, I want to prevent Mr. X so that he cannot submit the assignment. See, he cannot complete the assignment so that his boss may take some action against him. With that intention, with that fraudulent intention, I spoke these particular words to Mr. X, which created a sensation, a panic in Mr. X, and Mr. X, leaving all his assignments, everything in his office, ran to his mother in hospital. These are facts. I hope I could explain the illustration D properly. Before going to the next illustration, I am reading this illustration again so that you can understand properly. That a man holds certain opinion, has certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation, is a fact. I hope I could clear myself. If you guys has any doubt, you can directly contact me in my email. My email ID is prithwishganguli@gmail.com. I'll be very happy to answer, to reply all your queries. Illustration E. That a man has a certain reputation is a fact. I'm telling you a story. When I was in college, our principal was Dr. Somnath Mitra. He used to take our evidence class. To give lectures for hours on evidence, he needs no book, no notes, and nothing. Nothing. He has that much of confidence, depth in evidence. I know that Dr. Somnath Mitra is a very reputed person. At least I honor him the most. In my 22 years career, I didn't find any second person who has that much of depth, that much of confidence in evidence. So, this reputation of Dr. Somnath Mitra, my respected professor, is a fact. Now I am coming to the next definition, relevant. One fact is said to be relevant to another when the one is connected with the other in any one of the ways referred to in the provisions of this act relating to the relevancy of fact. So what is relevant? When one fact is connected to another fact. How it is connected? As per the provisions of relevancy of fact. We will come to the point relevancy of fact later in our next video. You will get a lecture on this point. But as of now, we have to learn what is relevant. Say for example, one fact is connected to another. How it is? I have consumed lots of liquor and I had gone out of control. And at this situation, I was driving. I smashed my car on a lamppost. One people was standing there. He was killed. So there are several facts. Fact number 1, he went to the bar and consumed liquor. Fact number 2, after coming out of the bar, I started driving. So I am driving in a drunken condition. So I consumed liquor sitting in the bar and my driving the car in a drunken condition. These two facts are related. So they are relevant. Now, fact number 3. During driving in a drunken condition, I smashed the car in a lamppost and killed a person standing over there. Unless I was in a drunken state of mind, I would not smash the car, I would not drive in that manner. So these 3 facts are related, connected, and these 3 are relevant to each other. Today I will finish this lecture. After this, just next definition, facts in issue. The expression facts in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. A little bit difficult. Let me explain. The expression facts in issue means and includes any fact from which either by itself, means from that particular fact, or in connection with other facts, relevant fact. Either the fact that I am sitting in a bar and consuming liquor, or the facts relevant thereto, the consequent facts. I drove the car in a drunken condition, I smashed the car on a lamppost, all this. Any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability, disability. Liability, I smashed the car and killed a person, that is my liability. Disability, I was under the influence of liquor and my brain, my mind was not working properly, that is my disability. Asserted or denied in any suit or proceedings. Suit or proceedings means it may be a civil, it may be the fact in issue is applied to civil matters in suit, or proceedings in criminal matters, necessarily follows. I am again reading the section. The expression facts in issue means and includes any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right. Right means in civil suit, if any of my right accrues from any particular fact. My grandfather purchased a plot of land. This is a fact. Thereafter, my grandfather gifted that land in my name. That is another fact. But these two facts are related, so they are relevant. And due to such gift, my right accrues over that plot of land. I became the owner of that plot of land by virtue of that gift. Previously, my grandfather was the owner, but after the gift, I became the owner. So my right accrues. Liability, I discussed previously, or disability, I also discussed previously. Asserted, confirmed, this is my right. Or denied, I denied that my elder brother has no right over this land because my grandfather has gifted this particular land in my name. So my elder brother, my younger brother has no right over this particular land in any suit. So all these statements must be made. Assertion or denial must be made either in a suit or in a proceedings, necessarily follows. Explanation. Whenever under provisions of the law for the time being in force relating to civil procedure, any court records and facts an issue, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. Again, I am reading. Read with me. Whenever under provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, records any statement, issue of facts, the fact to be asserted, either it is to be confirmed or denied in the answer to such issue while court is answering that issue. Either court should assert it or deny it, is a fact in issue. Now I am going to illustrations. A is accused of the murder of B. At his trial, the following facts may be in issue. Number one, that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocations from B. Sorry. That A, at the time of doing the act which caused B's death, by reason of unsoundness of mind, incapable of knowing the nature, all these are facts in issue. A is accused of murder of B. Now there are several issues. At the trial, the following issues will arise. That means court has to decide these matters. That A caused B's death. It is to be confirmed that the death of B was caused by A. Now next, intention. Whether A had the intention to kill B or not. This is also to be answered at the end of the trial. Number 3. The defense raised a defense that A received sudden provocation from B, and out of that sudden provocation, at the fit of anger, A killed B. The defense lawyer raised this point, took this defense. Now court to answer this point also, whether A received any sudden provocation from B or not, whether the murder was caused under the influence of such provocation from B or not. And number last, that A at the time of doing the act which caused B's death, by reason of unsoundness of mind, A is not at all mentally fit. He has some sort of mental problem, or he was during that time under the influence of liquor, or during that time he was suffering from any illness which caused his some sort of mental disability, incapable of knowing its nature. So the mental disability or unsoundness of mind to be such extent that A was not at the position to understand the consequences, that his act will kill B. All these answers are to be given by the court at the time of passing the final judgment. I hope evidence is a very, very large, huge subject, and we should not proceed with this subject rapidly. Rather, we should proceed very slow and steadily. I think today I should end the class at this point. In my next session, I will start from document. Till then, I will request you to read this portion, this 1 page or 1.5 page, as much as you can, and your every reading will reveal some new things. You will understand some new points, some new angles of these few definitions. So we will upload our next video, which will start from the definition document. Till then, I will take your leave. And one request, if you like my lecture, my humble request to all of you to subscribe my channel so that you can get the notification of every upload of videos instantly. If you like my lectures, please comment. If you have any suggestion so that I can improve my lectures, I can improve my classes, don't hesitate to suggest. I will be very happy to read your comments. And before ending, I will again request you read the definitions word by word, letter by letter, thoroughly and thoroughly. Till then, thank you very much.